YouTube, it's Tom back with another one for you. And so this one is a continuation of creditors and their bonds. This is number 11. All right, let's get right into this shit. So this is a continuation of the process of what is it? Accepting and returning for value the commercial presentment, which all crimes are commercial, on the private side, right? So this is the process, and I forget who the fuck wrote this. I believe it's Yusuf L. Either that or he rewrote it or some shit. Either way, this shit is fucking fire, bro. That dude Yusuf is a fucking savage. Go check him out, Yusuf L. Find him, Google him, and they go pop right up for you. Nigga's a beast. So here you go. Prepare your bond to bond the case. This is the bond that completes the accounting for the court. It has the charge on the books, but it does not have the offsetting bookkeeping entry. This bond is what has the books out of balance. When you put your bond into the case file by filing it with the clerk of court, it balances the books. Attach a photocopy of the docket sheet to your bond to verify the lack of a bond in the case. I do not know why it is not notarized, but my guess is that it is coming from the private side and not the public side. So things don't necessarily have to be notarized by a public so when you get something notarized, it's by a public notary. That's what makes it valid in the public. You can go ahead and notarize your own shit with a stamp and cancel it. So that's still going to be notarized by you, but it's going to be on the private side. So you want to get in the habit of using the $1 stamps and canceling those as well. All right. So those are going to put you in the position of being the postmaster, the judge, the magistrate, all of the fucking above with the stamp tech. So I posted something about removal of the jurisdiction. I did a video on it, and there's a link in the community section with a link to the book, and you can access my boy. He's a real good friend of mine that actually wrote the book. And he does consultations on how to fucking remove jurisdiction using the postal stamp tech. All right. So if you have a notary, public notarize the signature. You may be mixing private and public, and there are no profanaries to be found anymore. I don't know what the fuck that word is, so I'm not even gonna pretend to. So even if we had proto notaries, okay, that may cause a conflict since they are totally under admiralty law now. The bonds that have been used already were not notarized. If there is no defense attorney, you can enter the certificate of non-response into evidence and request judicial review of the administrative process, which is always good to be able to do that, to have your whole cases in general reviewed by justice and things of that sort, because there's a lot of fraud that goes on behind the scenes, as you can imagine. So remove the case. If the judge does not dismiss the charges by discharging the bond, you can remove the case into another court with an amendment complaint for judicial review, using the original case filing fee to cover the filing fees in the court to which it is being removed. This might mean removing the case from the justice court to county court, or from county court to federal court, or from civil to criminal, or from criminal to civil. Sometimes the same judge can be on the original case and on the removed case. It is important to understand that you are not asking for a default judgment from the new court. You are asking for a judicial review. You want a judgment in estoppel, not default judgment. So that's going to put them in the position. The estoppel is a fucking amazing. So it's a judgment order from a judge, which so when you do the contracts that we actually offer as well, you get your judgment, and it's from a notary, which is also a magistrate as well, right? So you get your judgment from the estoppel, and it is from a judge. It is from a fucking notary, which is a goddamn magistrate, which actually has more power than the fucking supposed judges, which are all just clerk magistrates anyway. They're all under the magistrate. The clerk magistrates are the judges. And if you don't believe me, look where these judges are signing. They're signing right in the clerk magistrate section. They're under the magistrate. Okay, so that means that a public notary is a fucking magistrate with more power than one of these fake judges. So the default judgment is already finished. The notary did that. The respondent was in dishonor. He defaulted on his duty to respond, and they have a duty and an obligation to fucking respond to you because they're your servant. So when the notary issued the certificate of non-response, she was certifying the default. Sit back and observe the play. You have done all your preparation work. Stay alert. Do not participate if there is an appointed public defender. Let him be your mouthpiece. Do not hire an attorney, though they do not appoint public defender. You may have to participate enough to get your third-party witness as the agreement of the parties and your status as the creditor on the record. Don't screw it up by dishonoring your own status as the creditor on the cases. They will try everything to get you to 1. Testify, argue, call witnesses, file an answer, explain your private process, dishonor the judge, dishonor the prosecutor, dishonor your lawyer, join the commercial process, hire an attorney, all of the above. And you know what? I've even fallen into these fucking traps, because when you let your fucking emotions get the best of you, which sometimes they do, for me too, I hit them with some fucking disrespectful nonsense. I do that shit. I mean, I'm from the fucking hood. What the fuck do you expect from me? And they know how to poke at your weaknesses and shit, and I still have them too. You know what I'm saying? I still have the weaknesses and shit. They can sometimes get me to react, but the one thing they'll never be able to do is figure me out. So you can ask your witnesses questions about the certificate issued by the notary. Did you respond to my notice of acceptance and the request for confirmation? Did you send me a copy of notice of dishonor from a qualified third party? And did you cure your breach? And so that's one of the things that you definitely want to know. You'd be like, look, so I already put you guys on notice as to the fact that you guys breach your fucking fiduciary duties and maladministration of trust and all that, right? And you're putting them on notice, making them the holder in due course when you serve them with a bond in order to discharge the fucking commercial matter at hand. And so they have an obligation to entertain that, the same way that you do when they send you a fucking letter. You have to do something about it, right? Or else you end up in an administrative fucking defaulted fucking position, right? And so you give them an opportunity to cure. So when you ask them if they cured their fucking default, that's what you're talking about. I gave you an opportunity to cure. And then next from there is fucking default. Okay? Administrative process. Learn it. So here it says, is there a problem with the judge? And if there is a problem with the judge and the other actors accepting your acceptance, there is always a wonderful question to ask. Your Honor, will your bond withstand the commercial liability of the charges this court is entering today? Do not participate in the courtroom drama. The court-appointed public defender speaks for the defendant. If there is no public defender, you can make your own points, but you are limited to a very few issues. There is no controversy. You want settlement and closure. You have accepted the judge's oath and have a contract with him. You have bonded the case. You do not do any of these things listed above. There is a public defender. He is the only one who can speak from your side of the courtroom. As long as there is a defense attorney, the judge cannot see or hear you. You guys are on different planes, okay? So if you try to truck out of frustration or to try to get clarification, you will lose your position as creditor. Debtors testify, argue, call witnesses, file, and dishonor. You are not the debtor. When the judge and you're not the debtor. They're the ones that created the fucking debt. They're the fucking debtors. All right. So they're creating a debt out of fucking thin air, and they want you to feel obligated to entertain their shit by arguing it as if you fucking somehow owe them something. You don't. They created the fucking debt. He who brings the fucking charge has to bring the resolution. All right. So it's really that simple. So when the judge asks how the defendant pleads, it is your counselor who will answer. His answer is B, that he is a statement to read into the court. The statement should be your letter to the counselor, which is telling him this. So everything in your letter to the counselor is designed to have him act in a capacity as a lawyer for his clients, not as a fucking lawyer for the fucking defendant, right? So while he protects your private interest and negotiates closure and settlement for you, he is not permitted to defend the defendant, the straw man. He is not permitted to argue any of the facts. He is not permitted to engage in any controversy at all regarding the case. His job is to be your mouthpiece in the proceeding. He is an officer of the court and has the capacity to speak in that court. If there is a public defendant, you never speak in court. If you do, you will negate the relationship you have with him by dishonoring him. You will not be acting like a creditor. You will be acting as though he is incompetent to represent your creditor position and bring closure to the case. Remember rule number 2, stay in honor. You are authorizing the counselor to negotiate the settlement for you. Stay out of his way so that he can keep your mouth shut in court. You are not going to testify ever. Debtors testify. Debtors defend themselves. Debtors dishonor. The term might be that the straw man pleads guilty. This is for your public show. It should be It should be a problem for you to enter a plea of guilty into the facts for the defendant. You are not disputing the facts. It should be you are not disputing the facts, and it should be a problem for you. And it should not be a problem for you to enter guilty to the charges. Once you have the appearance bond, and upon issuance of the appearance bond, the lawyer can enter a plea of guilty for the defendant, because your exemption is bonding the whole case. When you accepted and returned the presentment and attached an instrument to discharge all of the charges and sent your letter of credit to the secretary, you gave notice to the public that you had accepted the presentment, and you became the creditor of that case at that point. So these are all different scenarios, hypothetical, naturally, scenarios, and how they would and wouldn't play out according to the rules of the game, because it is a fucking game. All right. So this here is an example of a certificate of non-response, right? And so this is after you send up the bond and all that shit, and they decide not to fucking answer you back, which they have an obligation and a duty to perform in a certain fashion, and that is the role of a public servant. Okay, so they don't have the liberty to fucking pick and choose what they will and won't fucking respond to from you. They have to fucking reply to it all. So that's why a lot of the times they'll just silently acquiesce into your default judgment, and that's okay too. It's fine. You're not gonna force them to fucking admit guilt and shit. It's it's not gonna happen. So acceptance by John Henry Doe is John Henry Doe of complaint on number whatever it is, Susan Smith, and the notary who verified Dave Brown's dishonor. So, a notary, which is a magistrate here, is verifying the fact that a judge went into dishonor and all that shit. So you're getting the judgment either way. It doesn't have to be from them fucking directly. You're still getting it. All right. So pursuant to state law regarding evidence. And then here we have all the codes associated with that. The record shows I mailed a notice of brief to Dave Brown at ABC Agency. Your certified mail package number, your certified mail number here, RRR, as verified by certificate of service, which you always get from your notaries. That's why you got to get comfortable with using notaries. After acceptance of both mailings, Dave Brown for ABC Agency refused to send the confirmation that the account for case XYZ had been adjusted and settled, nor a notice for dishonor from a disqualified third party, excusing his refusal in the 10-day allowance for the second mailing. Dave Brown, ABC Agency, did not cure his dishonor. He gave no reason for his refusal to confirm the adjustment and settlement of the account or send a notice of dishonor. So they have to send you back the bond that you send them with a notice of defect in order to explain the reason why they're not fucking accepting it, in order to for a closure, settlement and closure of the fucking accounts at hand, right? So therefore, based on the foregoing facts, I certify that Dave Brown for ABC Agency dishonored John Henry Doe, me, through his non-responsive action or lack thereof, and did thereby agree that John Henry accepted the subject complaint case for XYZ, returned the complaint, exchanged his exemption for the discharge and the associated charges, presented an authorization for the use of his credit to set off all associated court charges, including the processing instructions, including a statement of account showing a zero balance, sent a letter of credit to Timothy whatever, as notice of that exemption was being used to settle the account, which would be your case number. Further, Dave Brown agrees that his refusal to send the written confirmation of the settlement account number or notice of dishonor from a qualified third party in no way negates the fact that said account settled and closed, and that he and the agency he represents have no capacity to pursue collection on said account, and that further pursuit of collections is agreement that Dave Brown and ABC Agency collectively and severably owe John Doe X amount of money, because you're gonna get your default judgment and your penalty for these motherfuckers not doing the job correctly for expenses in handling John Dave's Brown's presentment, that John Doe may take all necessary steps to secure his claim and that the debt is owed and collected to. So then you can go ahead and start, serving these people with invoices and things of that nature to go ahead and get your motherfucking money, boy. To get your motherfucking money. All right. So here's another example of one of the notices, and so we're gonna get into a couple more in the next video too as well. So and I also, if you guys want this book, send me an email. I'll send it right over to you. These are all fucking awesome things to have. All right. So here it is. A notice of acceptance. So notice to agent is notice to principal. Notice to principal is notice to agent. So notice of Acceptance. Please be advised that I have accepted your presentment to John Doe, the all caps, for assessed value, and I am returning it to you in exchange for closure and settlement to account XYZ. Please send the confirmation that the account for case XYZ has been adjusted and settled to the address shown above, or send a notice of dishonor from a qualified third party. I'm also enclosing an authorization for you to facilitate the use of my credit to discharge all the court charges that may apply. The instructions and statement of account are attached for your convenience. John Snow is also being notified that I have using my credit for this purpose. Your refusal to send the confirmation or notice of dishonor will in no way negate the settlement and will be agreement that you and your agency have no capacity to pursue further collections. Effort confirms your agreement that you and your agency collectively and severably owe John Doe $5,000, and John Doe may take all the necessary steps to secure its claim in the debt owed to it and to collect. Thank you for your immediate attention to this matter. All right. So those are freaking examples right there. Awesome stuff to have. This is how shit works behind the scenes to get all these fucking matters closed and dealt with ASAP. And things to keep in mind, you know what I'm saying? So, you know, they're not going to tell you what all your options are. They're only going to tell you what the options are that they want you to fucking pick from. So this is really how cases should be handled in the fucking background. Definitely know what you're doing. Check out Yusuf L's channel. He does this shit for a fucking living. He does consultations and all that shit. Hit him up for that. Me personally, I specialize on the debt elimination, promissory estoppel, and do not detain, which is pretty much the same. It's one and the same, you know, but I just call it what it is by its fucking legal name. So hit me up if you need any of those contracts done, and if you want to get into one of those classes. I'm going to be starting the group classes too, probably in a couple weeks. It seems like there's a lot of interest in that, so I'll probably be able to get that going, get the money order classes going and shit like that, so you guys can learn how to discharge debt ASAP. All right, so it is the game of chess. Stop playing checkers with these fucking assholes. That's what I got for you for now. Until we meet again.